And now I am so delighted to be able to introduce our speakers. Dennis Parker is Executive Director of the National Center for Law and Economic Justice. He previously served as Director of the ACLU's Racial Justice Program. He publishes and lectures extensively about civil rights and is an adjunct professor at New York Law School. Dennis is a member of Trinity Church in Ossining and a member of the Repair Organizing Committee. Carl Weber, our interviewer and organizer of the program along with Dennis, is a writer, editor, and publisher of nonfiction books. He has worked with authors including former President Jimmy Carter and Nobel Peace Prize winner Muhammad Yunus. He attends the Church of St. Barnabas in Irvington and is also a member of the Repair Organizing Committee.
Thank you, Anne. Those of you on Zoom, many of you have your screens covered for now, which is fine. I do want to ask if you can hear us clearly, could you wave or signal so that we know that, okay, good, I think our microphone is working. And later on, when we have open question and answer, we'll invite you folks to unmute yourselves so you can take part in the conversation as well. But thank you all for coming out. It is wonderful to be here. And as you may have heard, we are recording this program tonight. We'll make it available on the Repair YouTube channel. Yes, there is such a thing. So that people who weren't able to make it tonight will be able to hear some of the insights and information that we'll be sharing. I mean, it's kind of interesting. The camera is facing this way, so Dennis and I will be in the video. I guess if anyone in the group here wanted to ask a question that involves some kind of a personal revelation, in a way, this might be, you might feel comfortable doing it, knowing that your face is not to be on the screen. So if that makes a difference, that will be part of the equation with the recording. So our topic for tonight is the 14th Amendment. And Dennis and I, before the crowd started to gather, we were speculating, is anyone going to show up? Doesn't that sound like kind of a wonky subject? 14th Amendment, is this just for people from the legal community? And in fact, it's extremely relevant to so many of the issues that we're facing as a country these days, and actually understanding also the history and the role of the 14th Amendment means a lot to all of us who care about racial justice. So we thought actually spending an evening talking and learning about it and about its ramifications could be really interesting. And we're very lucky that we have a legal expert who has devoted his life. In some ways, I guess I can say that you've devoted your life to working out the ramifications of the 14th Amendment and trying to make it a living document that actually helps to make racial justice a reality for more people than it has been. So you've lived on behalf of the 14th Amendment in many ways. So Dennis is the perfect person to teach us about the meaning of this part of the Constitution.
David, do you want to watch the 14th Amendment?
On Zoom, if you're on Zoom right now, I recommend that you mute your microphone, please.
I'm gonna mute them anyway, Carl. Sorry.
Okay, but then Kevin, when we get to the open Q&A, will they be able to unmute themselves?
They sure will.
Okay, very good. You're all being muted now.
Okay.
But
Big
not
brother,
for
sorry.
nefarious reasons. So let's begin by talking about what is the 14th Amendment? What does it mean? What's the story behind how and why it was created? We all know that the Bill of Rights is Amendments 1 through 10. So why was the 14th Amendment necessary and what was its purpose?
Yes, and first of all, thanks to everyone for joining us. This is my favorite amendment. I like the First Amendment and like a lot of the other ones, but this is the one that really holds a special place in my heart. And as Carl suggested, part of that reason is because so much of the work In addition to the ACLU, I worked for the NAACP Legal Defense Fund, doing school desegregation cases and in other capacities, have relied heavily on this amendment as a way of achieving some level of equality in the United States. And the interesting thing about the 14th Amendment is, and when you ask why did it have to happen, you can't understand that without looking at what happened before. And there were a lot of things. It is a post-Civil War amendment. And whenever you talk about the Civil War, I was telling Carl that in preparation, I found myself reading one of my favorite speeches, which is Abraham Lincoln's second inaugural address. Really one of the most powerful. And if you don't mind, I'd like to read just a couple sentences from it. And he's talking about this country's legacy of slavery and what it did to us and what we owe to the people who had been enslaved. And he says, yet if God wills that it continue until, referring to the war, until all the wealth picked up by the bondsman's 250 years of unrequited toil shall be, I can't read my own
Shall be sunk.
yes, shall be sunk into every drop of blood drawn with the sword, as was said 3,000 years ago. So still it must be said, the judgment of the Lord are the judgments of the Lord are true and righteous altogether. Now that's something you don't hear many people say. What he's saying is our history is so horrid that this war, and 620,000 people died in the Civil War, almost as much as every other war that this country fought for. And in the face of that bloodshed and that violence, he said, that might not be enough to pay back for what we have done. When's the last time you've heard someone say, we have this level of responsibility and blame to adjust? And it, one of the things that, and I do want to talk about the history because it's important, that I thought of when I was coming here tonight is a recent candidate for the presidency of the United States who announced that this is not a racist country and it's never been a racist country. And it is such an incredibly remarkable statement to make for some of the reasons I'm going to be talking about. And these are the reasons why we needed the 14th Amendment. Now, the quick answer is we needed the 14th Amendment because we had the Civil War in which 620,000 people died. We had the 13th Amendment, which said you can no longer have slavery unless you've been convicted of a crime. And then,
Which turned out to be a big loophole.
yes, a huge loophole, and that's another subject. And then, so you had this amendment that freed people who had previously been enslaved. And then that left the question of, well, who are these people? What are their rights? And that was the reason that the 14th Amendment was passed. And specifically, it was passed because of an earlier decision, the Dred Scott decision, which dealt with, Dred Scott was an enslaved man who was owned by army officers who moved all over the country. And at one point, he was enslaved mostly in Missouri, but the person who had enslaved Dred and his family moved to Illinois, which was a free state. And Mr. Scott, who enjoyed a brief period of freedom in that time in Illinois, was taken back to Missouri. And he said, well, I was free because I was in a state where slavery is illegal. So therefore, I cannot be enslaved in Missouri. And he brought this lawsuit to protect his newly found freedom. And we're going to talk about the impact of the patterns of change with Reconstruction and post-Reconstruction in the 20th century. But this idea of being free for a while and then suddenly seeing that snatched away from you is a theme throughout American history, which continues up to now, and that deals with race or reproductive freedom or a whole range of issues. It will not surprise you to hear that Dred lost, and the court held that in a decision that's widely considered to be the worst Supreme Court decision in our history. But what's interesting to me and what involves the 14th Amendment is the court's analysis of why Dred had to lose. And what the court did in this enormously long opinion is look at the history of the United States and looked at the way Black people were regarded during this history, and look back to the Declaration of Independence and the Constitution, and concluded after looking at it that there had never been an intent to include people of African descent in the promises of the Constitution, so that when they meant all men are created equal, they didn't even have to say, oh, except for Black people, because everyone knew that they were not people who were not entitled to that protection. And again, that's enshrined in the Constitution. It's enshrined in the language that says, for purposes of determining how many representatives you have, 3/5 of slaves will be counted. How you doing? That 3/5 will be counted. And the reason for 3/5 is not that they only got 3/5 of the rights. They got none of the rights. But those numbers went to the slave owners, and it assured that the southern states with large numbers of enslaved people disproportionately got representatives in Congress. So from the very beginning, it is enshrined in there, but there is language, and this is easier to read because it's not my handwriting.
This is from the Dred Scott.
This is from Dred Scott. And he's talking about, he makes a really remarkable, the justice who wrote this opinion, but it was concurred in by most of the people, that he says that proof that slavery is what was intended is that the people who created the Constitution were smart people and were sophisticated. And if they believed that it was good, then really must have been pretty good. And so he said, with regard to Black people, they had for more.
Could you look at the screen? There's a message there. Something we need to do?
Ed Perk is requesting AI companion.
Turn off that.
I don't know what that is.
So with reference to Black people, he said, this is a long answer to a short question. I'm sorry.
No, this is what we're here to hear.
With referring to our founding fathers, because they were fathers, and they were white, they had for more than a century before, or I'm sorry, now he's referring to Black people. They had for more than a century been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. He was bought and sold and treated as an ordinary article of merchandise and traffic whenever a profit could be made by it. This opinion was at that time fixed and universal in the civilized portion of the white race. It was regarded as an axiom in morals as well as in politics, which no one thought of disputing or supposed to be open to dispute. And men in every grade and position in society daily and habitually acted upon it in their private pursuits, as well as in matters of public concern, without doubting for a moment the correctness of this opinion. And this is the foundation on which the country was built.
And it's important, tell me if I'm right, to remember that in this decision, using that language that you just read, the judge who wrote that was not saying, and of course we know how wrong this was, he's saying that's what the founders believed, and that's the doctrine we have to stick with today, is what he was saying, in effect, in the draft.
Right, he's saying now, people may be changing their opinions now, it's years later. And, but he's saying that this is the foundation we have, and it is still a fact. And he went even further, because it's not just about people who were enslaved. He was speaking about anyone who was of African heritage. So that if you were freed, you were still not a full person. And you still did not have rights that you were bound, that people were bound to obey. And the manifestation of what this meant included things like, if you were to savagely beat an enslaved person, you would not be charged with a crime, at least in regard to the person you beat. If you were charged with anything, it would be for hurting the property of another person. And so all of that extended to beating, to rape, to all of those things. Those crimes did not protect Black people for a significant part of even before the Civil War. And so what the court said is, because neither he nor his free brothers and sisters, well, certainly not sisters because they couldn't vote anyway, but he and his free people were not citizens. They could not go into court, so therefore the case will be dismissed because they were not people. And significantly, they were not citizens of the United States. And it's a primer on supremacy and hierarchy. He refers to Indian tribes, and he says, they're savages, make no mistake about it. But if they wanted to be Americans, they could be. But that's different. They are a sovereign nation. They were here before. And as savage as they are, maybe they, if they live among white people for a long time, could be civilized. But that's different from people who came here unwillingly and could be bought and sold. So that was the problem. They were saying that you could not be a citizen. And what the court went further and decided to surprisingly rule on the Missouri Compromise, which limited the spread of slavery in new territories. And even though that was not an issue in the case, they declared that unconstitutional. So that was the background. The 13th Amendment freed people, but you had the Supreme Court case that was still law that said they're not citizens, free or enslaved.
Okay, so now we have a Congress. The Civil War has been fought and won by the Union. Slavery has been ended by the 13th Amendment. You have a Congress that has a majority of Republicans, and the Republicans under Lincoln at that time, and his Republican partners. The Republican Party at that time was the party of civil rights. So what did this Congress attempt to do in the 14th Amendment? What are the elements of the 14th Amendment?
Well, the important thing, and this is a theme that's important, is they realized that the 13th Amendment wasn't enough to make these newly freed people equal. And so the purpose of the 14th Amendment was to make them.
Okay, and what does it actually say? Do you want to read any
Sure.
of the text? How many clauses are there in there?
4.
And are they all sort of
5, I'm sorry.
Okay, do you want to give us the gist?
Yeah, well, the one that I'll be mostly speaking about, although obviously the one that is of interest now is also the third section, which deals with insurrection and whether you could hold public office. I mean, that's why this is such a cool amendment, because it covers so many different areas. But the First Amendment is important, particularly for both newly freed people, but also, as we'll see, for other groups that get protections. So it says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or the immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws.
Okay, so anyone born in the United States is a citizen
Yes,
and is entitled to the equal protection of the laws.
right,
So that's a pretty big
and
And
to the
bold.
due process, yes.
and due process. That seems like a pretty big and bold claim, but especially for the time.
It was, and it was a heated debate, although it obviously passed by the, significant majority that is required to amend the Constitution. And what is interesting when you look at when it was passed and what Congress was looking
Yeah,
at.
what year was that?
Actually, I'm not sure. Yeah, 1868, I'm sorry.
68, okay.
It was ratified.
So within 3 years after the end of the Civil War.
Why didn't women get the vote at that point?
It was debated at the time, but there were even, it's an interesting and complicated question. There were debates. Frederick Douglass, for instance, was a big supporter of women getting the vote, but I think that there was this sense that we're going to concentrate on treating the newly freed people, and because only white men could vote, then that limited it to Black people.
But surely they realized that in saying anyone born would include women.
Well, they're citizens, but they, wouldn't necessarily have the right to vote.
Okay, so the amendment was passed and continue the story now.
So
How did it get enforced, or how does a constitutional amendment get enforced? And what actually happened in terms of carrying out the promise that this amendment now makes to all these new citizens?
well, it first provides protection against certain things, so that you cannot, for example, prohibit people from holding political office. The state cannot do that. I mean, it basically says that whatever the government does has to be equal for everyone. And there were also specific laws that were passed at the same time as the 14th Amendment that significantly were targeted at Black people and Black institutions. There was a Freedmen's Bureau Act, which was designed to give freed people access to jobs and to farms and things like that. There was a provision that required that Black soldiers be compensated. All of them extremely racial specific.
Was the Freedmen's Bureau, was that in effect a form of what people now call reparations?
It was in essence,
Okay.
and there were a number of programs like that were endorsed, at least by the majority of Congress. But a lot of the enforcement was done by the presence of the army in the rebel states, and so the remarkable thing about that period after the war is that there were actually more people in state legislatures and in the federal legislation, more Black people than there are now. And there were just large numbers, and for a brief period, it appeared that we were moving in the right direction. But that ended, of course, with Lincoln's death, and with the withdrawal of the Northern troops. There was a really quick change back, some of that overseen by the Supreme Court.
And it was I'm dipping back into my American history now, and you'll have to help me. There was a contested presidential election that was part of this story, right? Where the Republicans and the Democrats agreed to resolve the question of the presidential election, but with the withdrawal of the Union troops from the South as part of
As one of the, right.
Yeah.
And again, this was.
1876, this must have been.
So
right?
this was after, I mean, it may have been a different outcome had Lincoln finished
Right.
his,
Survived.
but yeah, there was a sort of change, not only in the South, but in the North too. And I'd mentioned that in the cases that were brought, there were a series of laws that were passed of general significance, the ones that forbid or that required that all people have a right to enter into a contract, the same as white men. But again, John is referring to
Males.
males, and there were all of these statutes. That's called 42 USC 1982, and there was another one dealing with property. And in 1875, they passed something that said that should be extended to public accommodations. And the Supreme Court struck that down and said, the 14th Amendment talks about states. It doesn't say that if you have a restaurant, you have to welcome Black people in, because that's invading the privacy of the restaurant. And there's language in it that says, Black people cannot be, the special recipients of the law. So we're not going to protect them there.
You're taking the prompts from the person who inputted it, and then adding the term ethnically ambiguous, because the problems in early testing.
You're on our, we could hear the.
They what? They call it caricatures?
Are you muted?
Yes.
Okay.
Is that, are you addressing the group here, or is that a private conversation? Yeah, hit your mute button if the latter. Go ahead. Dan.
So, but the big thing is that, so in the latter part of the 19th century, suddenly a lot of the advances were lost.
Yeah.
And it was the Plessy versus Ferguson case that kind of cemented it and led the way to the reintroduction of Jim Crow into the parts of
Talk about Plessy versus Ferguson. I think most of us have heard of it in counterpoise with the 1954 Brown versus Board of Education ruling, which overturned Plessy versus Ferguson. But what we may not necessarily know what Plessy versus Ferguson really was. Can you talk a little bit about that?
Yes, and it's a complicated case. It's a case from New Orleans, Al. And
it was 1898, I
yeah,
want to say.
Mm-hmm.
Yeah, okay.
And New Orleans had a law that required that Black people and white people sit in different streetcars. And there was a group with a long friendship.
Stephen Jacoby, is that somebody you know?
Please mute.
This is Stephen.
What is it? Show me?
I got it. Go ahead.
Thank you.
And so there was a group of Creole folks in New Orleans. They probably would not describe themselves as Black. They probably would have described themselves as quadroons or octoroons or any of the other names for colored people. But they were understandably offended by this law, which forbade Black people from sitting in the same car with white people. And what was interesting is they weren't the only ones who didn't like the law. The streetcar company didn't like the law because it required that they have two cars rather than one. And that was expensive for them. So the two groups got together and whatnot. People don't know this, but it was a test case. And it was a case that was put together by Black New Orleans residents and the streetcar. And they wanted to test the law by violating it. And they hired a private detective who would go in and arrest Homer Plessy, who was going to, the plan was go into the white car and wait and violate the law. Then the hired detective would come in and arrest him and take him to the police station. And they actually worked it out with the streetcar company about when it was going to happen and where it was going to happen. So it was a really, really tight plan. And the interesting thing about it is Homer Plessy was so light-skinned that had they not planned it, they wouldn't have realized he was not white. And so
he kind of had to say, I'm black, I'm black.
he sort of said that. And it's interesting because in the case that he brought, one of the things that he interestingly talks about is he talks about, you know, the law being unconstitutional, but he also says, and by the way, you know, I'm 7/8 white. And so you are taking away my property interest in whiteness by arresting me for being in this car. But at any rate, so that goes to the Supreme Court. And the court comes up with the idea of separate versus equal. And it says, yes, it requires Black people to sit in a different car than white people, but it also requires white people to sit in a different car than Black people. So what's the problem? And so they're saying that if there is anything offensive about this, that's in the mind of Black people, and they need to get over it, basically. And Justice Harlan, who was the predecessor of the 20th century Justice Harlan, says, listen, everyone knows what this is about. The reason you have this law is because you feel that Black people are inferior. It's not because you think everyone's equal, but, you know, because you want to coordinate colors on the streetcars, you know, you have this law. But he was in the minority there. The other interesting thing about the case is that he uses language which ends up getting twisted. And he talks about color blindness, but he doesn't talk about it in a way saying that the problem is we see race. He said the problem is we have a history of discriminating against these people. And this is a manifestation of that history. He also interestingly says, it's when you read the whole case, he says, listen, Black people are never going to be as smart or as industrious as white people, but the law says we have to treat them equally, which is something that they don't frequently talk about. They talk about that case.
Yeah.
But that gave rise to this whole argument that, you know, there's no problem, you know, that the problem is that, you know, Black people are too sensitive, you know, and that ushered in the whole series of Jim Crow laws. There was a play on Broadway when I was actually out of law school about a couple of Black women who lived in Mount Vernon, my hometown. And I can't remember the name of it now. It's like Having My Say or something.
Having Our Say.
Yeah, Having Our Say. And what was remarkable is in the play, and that one of the women said, I remembered the day that we went to the park and we couldn't drink from the fountain that we had drunk from our entire lives. And so the thought that there was someone living who not only remembered segregated fountains, but remembered before there were segregated fountains. And it said something about how recent this was.
And also about, as you said earlier, about the fact that it's not a one-way ratchet in the sense that once people get a right, then it never goes backward. It does go backward.
Oh boy, does it.
Yes, yeah, as we are seeing in a number of ways today. So, okay, so Civil War, 13th Amendment abolishes slavery. The Republicans in power at that point realize that's not enough. We need to give citizenship to the formerly enslaved people and guarantee equal rights for everyone who is born in the United States. That's the purpose of the 14th Amendment. But in the decades immediately following, that concept gets whittled down such that you end up with rulings like Plessy versus Ferguson, where Black people are clearly not being treated equally or fairly, and yet the Supreme Court finds a way to justify it or to reconcile it with the 14th Amendment, right? In other words, people who believed in civil rights wanted to point to the 14th Amendment and say, you know, this is not right, but the Supreme Court said it's okay, it's
Right.
justifiable because of the separate but equal doctrine. They came, in other words, they came up with a way, sort of work around. the
Right,
14th
and to
Amendment, in
blunt
effect.
the purpose of the amendment, and that's what held sway until Brown was decided in the mid-50s, and it's important, you know, particularly lawyers tend to think that what they do is what changes society by themselves. I'm referring to my sister here, who is a but there were other things going on that the court contributed to. And you know, you didn't hear it about when you were in school, but things like you know, Wilmington, North Carolina, and in you know, Kansas and all of these places where Black communities, you know, they had Black Wall Streets where they were successful, and they were destroyed because of that success.
By white rioters.
By white
yeah,
rioters. And you know, it always bothered me when 9/11, you know, when people would say, this is the first act of terrorism in the United States. And it's like, you know, we've been working on acts of terrorism for 250 years. We have it down. But those weren't recognized. And so all of these things were going on.
Yeah. Okay, so when we fast forward to the 50s and the 1950s and the 1960s, we have, you know, what we think of now as the modern civil rights movement. Is that a period when the 14th Amendment is being, I don't know, refurbished or brought out of obscurity, and people are trying to now give it its the full power that those who wrote it intended?
Yeah, and there were things that happened building up to it. You know, Brown wasn't something that was decided overnight. There were cases where they tore down the system of separate but equal. And by the way, it was never equal. It was, they got the separate part down, but the equal part didn't get done. And so there was a strategy of you know, I had the incredible honor of working for the NAACP Legal Defense Fund, which was founded by Thurgood Marshall. And actually worked on cases that he had brought 30 years or 40 years before, which is another story, the fact that they're still going on. But what they did is they looked at higher education and they said, you know, I want to go to graduate school or I want to go to law school in Maryland, but there's no law school that'll accept me. And what Maryland used to do is say, well, you can go to Harvard, we'll pay you, but we're not going to let you go to law school here. And so they originally said, okay, you're supposed to have equal, but we don't have a law school in the state. And the states would say, we don't want to build a law school just for you, so we're going to let you go to the white school. And they gradually began to erode.
I see. For sort of practical financial reasons.
Right,
yeah.
right. And then there was a series of cases like that. But Brown was the goal, and the goal was to say, separate but equal is a lie. And the function of Brown, and the interesting thing about Brown is they conceded, even if it wasn't necessarily true, that the schools were equal, because they wanted the Supreme Court to decide the issue.
You mean Thurgood Marshall?
Yes.
He was the lead lawyer on that
Right,
case.
right.
So he tacitly or
No, explicitly said, this
for the
isn't
sake of argument, we'll accept that they're equal.
Yeah.
Okay.
And so that forced the court to address the question. And it was an important case for a lot of reasons. One is it used expert witnesses. Kenneth Clark, a former resident of Irvington, I think.
Oh, is that?
Oh, Hastings, you're right,
Okay.
yes.
Does everyone know about the dolls? Do you want
Yes.
to talk about the dolls?
There was
So interesting.
part of the evidence that was used in the Brown case was they wanted to say that separate but equal stigmatized Black children. And part of the proof, and it's still controversial to this day, is they asked Kenneth Clark to do or he had done an experiment before and they introduced it, where he showed Black children dolls, some of them black and white. And then they asked the Black children, which is the smart doll? Which is the clean doll? which is the pretty doll. And the overwhelming majority chose the white doll. And so that was introduced as evidence of the fact that separate but equal caused this stigmatizing impact. And there was actually a ton of other evidence, but not all as dramatic as that. And the court considered all of the evidence. And, you know, again, you need to think about all this stuff in the context of what's going on in the world. It's 1955. The United States is going around faulting, you know, the Soviet Union as being, you know, violating human rights and all these things. And meanwhile, you know, we have forced segregation, we have apartheid in our country. And so there were a lot of interests that were being adversely affected by the existence of this system of apartheid. But for whatever reason, the court decided 9-0 that Plessy was just wrong.
Yeah.
That these laws were based in something that violated.
Yeah, and I read a biography of Earl Warren, which emphasized the fact that he worked very, very hard to make that a unanimous verdict. That he used his powers of persuasion and his sort of political clout with his fellow justices, because he said, this is going to make a revolution in this country, and we want to send a signal to the country that we all agree that this has to happen now. And
Right.
making it unanimous was a very important part of that.
And they literally waited for a justice to die, who they knew that they could not convince. And then, because one of the things that happened, it was a two-part case. The first part, it was up in the Supreme Court, and the Supreme Court said, well, we don't know enough about what the 14th Amendment means. Why don't you go back and tell us what it means in the context of history?
They asked the lawyers to offer their
And then they came back the next year and you know, told us the stories that we're telling now. And then the court said, well, yes, this was the intent of the 14th Amendment. The 9-0 says this is a horrible thing. This is something that will stigmatize children in a way that is unlikely ever to be undone. What incredibly powerful language. We are hurting 5-year-olds in a way that will hurt them for the rest of their lives. And this is such an important injury and such a horrendous injury that the court says, yeah, we'll address it sometime in the future with all deliberate speed. And in fact, what happened was a very long period of essentially nothing happening.
And we're still fighting.
And we're still fighting.
School desegregation, obviously, in many different ways.
Yeah, I like to tell people that I am working still on a case that was filed 32 years ago in Hartford, Connecticut. But anyway, but there were, the 9-0 lasted for a number of years. I mean, when they came back in the mid-60s and they said, okay, listen, you know, we said this 10 years ago, but now we're serious. You got to do something. And those early cases were 9-0. Yeah.
If the framers of the 14th Amendment had anticipated segregation, that kind of thing, and written it in that, you know, language that would have prevented that, would that have jeopardized the passing of the 14th Amendment in the first place?
It very well might have. I mean, it was not, you know, it wasn't that suddenly people said, oh, the war's over, let's be nice to Black people. It was a battle. So there were, I'm sure, compromises that were made. But it could happen. You know, this case I have in Connecticut, part of the reason that we were able to bring it is because Connecticut has language in its constitution that the federal constitution doesn't have.
So now, again, let's jump forward in time and come up to the present day, because the 14th Amendment has been in the news quite a bit lately.
For many reasons.
Yeah, and one of the terms you raised a little while ago from the first Justice Harlan's dissent was about this notion of colorblindness. You said he introduced that term. It has since been sort of abused and misused or twisted from what he originally intended. And it certainly is relevant to issues today such as affirmative action. So can you talk a little bit about this notion of colorblindness, how it relates to the 14th Amendment, how it does or doesn't relate, and the ways in which this notion of colorblindness is being used by people who, are fighting a rearguard action to defend segregation in various forms.
There are two schools of interpretation of what the 14th Amendment means. And one is the colorblind school that says that the problem is that we classify people by race. And once we stop classifying people, the problem will go away. And the other school, which you will not be surprised I attend, is the one that says this was designed to eliminate supremacy.
White supremacy?
Yes.
Yes.
And as we'll discuss, many different types of supremacy. And that it was intended to deliberately change all of those forms that inequality exists in. And what happens now is, if you've read the affirmative action cases, you'll notice that both sides quote Brown as supporting their position. And part of it is because some people will say, well, Brown was a case about colorblindness. And then other people will say, no, Brown was about the fact that you're hurting these kids and you need to change it. And that fight continues. And one of the cases that was important, and this is a sign in part of how old I am, and I'm getting older by the minute. My first year of law school, I was working as an intern at the NAACP Legal Defense Fund, and it was during the time when the Bakke case was being decided, and I remember
That was Harvard, wasn't it?
it was University of California.
Oh, okay, right, that's right.
And we got word, the office was in New York, but there was a Washington, D.C. office. So we got word that the decision was being announced. And it was exciting for me as an intern because, back then they didn't have fax machines. They had some sort of primitive version that had like a bird that would peck, it was like something from the Flintstones. And so we were, I was standing around, and Jack Greenberg, who was at that time the head of LDF and one of the Brown versus Board of Education lawyers, was standing next to me. And the case came in, and he picked it up and looked at it, and he said, "We lost." And if you're used to discussions about affirmative action, you may say, wait a minute, didn't we win because they said that you could consider race in a careful way when you're admitting people? And it's true, it says that, but it also said two other things. Number one is it said the reason you could consider race is because schools had a right to create diversity. So the interest that was being protected was not remedying the history of discrimination against Black people and the fact that there were no Black people in the medical school. It was the right of the school, a First Amendment right, to have a diverse student body. And then the second thing it said is, yeah, we know that there's discrimination against Black people, but it's this generalized discrimination. And unless you can show that this school is responsible for it, there's really nothing we can do about it. And so from that time in 1978, up until we, had this awful decision last year, all of the affirmative action cases had to be forced into this discussion of diversity and not into discussions of inequality.
Let me push a little bit and clarify for us why, in your view, and the view of, I think a lot of other smart folks like you, why is the diversity justification a weaker one than the one about remedying ongoing patterns of discrimination?
Well, for a couple of reasons. One of them is that in order to, I hate to get into this, but there's something called strict scrutiny, that if the government is considering race, it has to be really careful. And the court, and the courts are gonna look at it under a microscope to make sure that
In other words, there's like a presumption that including race
Is-
as a factor
it's bad.
is bad unless it can be justified.
And it can be justified by saying there's a compelling governmental interest.
Okay.
And that the way that you're pursuing that interest is so narrowly tailored that it's not gonna hurt too
And
many white
did
people.
this strict scrutiny standard come out of Baki?
It had actually come out of the Korematsu case.
Oh, okay. Oh, my people.
Your people, and it's interesting because as you know, Korematsu was one, maybe second or third worst decision in the history of the court, but it did establish this standard, this strict scrutiny standard, which is generally good. I mean, people were saying, well, we don't want to get black people, and they come up with something. And then normally what that would mean is, so you would look at it strictly, but now it was being applied to a white student. And I probably shouldn't say this on camera. One of the things that happened at the University of California is the way that they were trying to get Black and Latino students in was they had quotas. And the one thing that the Supreme Court said was, that's absolutely illegal. You can never do that. That was part of the reason why Jack said that
We lost.
we lost. And
Yeah.
the reason he said that was, and the reason I believe that is that Jack and I were cynically, but me, 21-year-old next to this incredible civil rights lawyer, were both skeptical of whether you could get rid of the problems of race without really requiring that people address it. There are countries in the world that say 50% of the legislature has to be women. And if you didn't have that, you wouldn't have 50% of the women, of the legislature being women. I think that's just a fact. But even my saying this and having it recorded, if I had a future, it might destroy it.
I think you're gonna be okay. We hope so. Talk about, I mean, we could go on, and there's so many ramifications that are fascinating. One of the ways this is all, the 14th Amendment in particular, is very much in the news right now, has to do with birthright citizenship, which is part of what the 14th Amendment guarantees. If you're born in this country, you are a citizen, no questions asked. And that is under attack.
Yeah,
correct?
it is under attack, and it's interesting because that's one of the earliest examples of ways in which the 14th Amendment benefited a broader class of people. And I'm not arguing that the only reason you could use the 14th Amendment is to help Black folks, but that was the reason it was passed initially. So one of the earliest cases was the case of
Well, Title IX, I guess, is really a child of the 14th Amendment, no?
well, all of them sort of derive some of their
Yeah,
power from
okay.
that, but a lot of it's spending clause, because it all depends on federal funds going to
Anyway,
but so where is it? I believe it was 1898, United States versus Wong Kim. And that is a case that involves two Chinese people who lived in San Francisco, and they gave birth to a child in San Francisco. And so you may be familiar, but you may not be, because I wasn't taught this when I was growing up. Treatment of Black people was really, really bad in the 19th century. But coming not too far behind was treatment of Asian people. And there was the Chinese Exclusion Act. There were times when Chinese women could not come to the United States because it was presumed they were all prostitutes. That Chinese people who built the darn railroad couldn't become citizens. And they had this legislation which closed down the borders selectively to Chinese people. So this Chinese couple could not themselves become citizens because of the laws. but they said that their child was a citizen. And it went up to the Supreme Court, and the Supreme Court said, yep, that's what this does. And
So the child did become a citizen.
it was a citizen.
Okay.
And that is the law now. There are efforts to try to work around it or to get amendments to the Constitution. And you hear about words like anchor babies and things like that, which is a really revolting concept, the idea that a human would be used as a tool to sort of.
Do people know what is referred to by that? So, I mean, there are people who conservatives, people on the far right who are against immigration, for example, often claim, oh, there are hordes of immigrants coming to this country when the woman is pregnant just so they can have a baby. So that baby is automatically a citizen, and then that person can then apply to bring all the rest of their family swarming into this country. That's the anchor baby idea. So they're saying this is why birthright citizenship is a pernicious doctrine, which is going to destroy our country because it allows all these foreigners to come in.
And so, certainly since the 1890s, that's been the law, and actually since the 14th Amendment, which states it. But it's interesting, even in the dissent to Dred Scott, the dissenting justice said, if you're born here, you're American. That's the way it should be. And I understand not every country has that, has a birthright, but that has been the system in this country. And when we depart from it, it is usually because there is some group that is disfavored who we want to keep from becoming citizens.
Right, like the Chinese at one time.
And now.
Now others. Before we throw it open for, people have been asking some questions, which is good, but we'll throw it open to all kinds of questions and comments. But one more thing I want to ask you about, because it's again part of why the amendment is in the news now, is the insurrection piece and the idea about excluding former President Trump from the ballot. Can you talk a little bit about that and sort of explain what that?
Yeah, and I'll explain what I know. I'm not a specialist in this at all.
But it's a different clause.
Right, this is section 3, and it says no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, who having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislative or an executive, so on and so forth, to support the Constitution of the United States, and shall have engaged in insurrection or rebellion against the same or given comfort to the enemies thereof. And so a number of states have challenged Trump's inclusion on the ballot, saying that under the section 3 of the 14th Amendment, he has engaged in or given aid or comfort to insurrectionists. I was going to say resurrectionists. We're all in trouble.
That's the whole
and that case has gone to the Supreme Court. There was an argument, and it's fascinating. Evidently, the pushback to Colorado came from both sides of the court.
Yes. So I saw here, yeah.
Both sides. Yeah. And you could argue about the reasons. I think some of it from the more progressive people may be, if this can happen to them, it could happen to us. Some people, a lot of the questions dealt with the ability of a single state to make a decision that has a nationwide impact. The more cynical among us, say that maybe this is them doing this, which helps Trump because later they're going to rule against. I have no idea what's going on, and I think we.
And I know some of the debates about it were really very legalistic, like it doesn't specifically refer to the president. It just says any officer. And there are lawyers actually saying, well, the president's not really an officer. Yeah, which seems like a stretch, but.
I know you said you're not an expert on this piece, but why was this put in? It seems,
Yeah.
was it to keep
Yes,
Civil War veterans from the South?
right. That was, and it's interesting because that came up in the argument. You know, you just had this war where half of the country were insurrectionists, and you know, one of the questions that was asked is, you know, well, you know, Jefferson Davis, you wouldn't want him running for president of the United States. And then the other side said, well, but even though it was put in place right after the Civil War, it was never invoked. Now, part of the reason, and you know, Justice Thomas said, all of these Southern Confederates ran for office and, you know, were chosen. Part of the reason
That's true. So he is factually correct.
He is factually, it's a half truth.
Okay.
The whole truth is that because Lincoln was so intent, you know, the last section of that second inaugural is how we have to get together and move on and
Right.
rebuild the country.
Right.
So there were massive pardons that were given
Mhm.
to Confederates so that they technically had been
Yeah.
pardoned.
And actually, the last part, I think, of that clause does say, unless they've been, unless this disability has been removed by Congress.
By 2/3 of each house. I mean, there was also an argument made that it would be unfair to eliminate Trump, who, you know, before Congress had a chance to, you know, remove that
Oh, okay.
that barrier.
Yeah. So it's kind of complicated.
It's
but-
really complicated, and you know, there are people who say that the timing is bad. I mean, it just feels strange. The argument that, you know, there may have been something that is illegal or unconstitutional, but we shouldn't pursue it now because it, you know, it.
Yeah, I mean, if it is clearly unconstitutional, it seems like it's important to stand up for that principle,
I
no
think-
matter what.
Mhm.
But. So, there's a lot to think about and digest there, and it really does relate to so many issues. What kinds of thoughts, comments, questions have people been mulling? And, I don't know, shall I call in people? How about? Yeah. And speak loud if you don't mind, so our Zoom friends can hear.
A question about this whole issue of diversity. Is that when did diversity become thought of as being racial, as opposed to why not saying, well, if we're going to be diverse, why don't we just have a whole bunch of one-legged people that makes it diverse? Or why don't we have blind people that makes it diverse? When did this become a racial issue?
Well, I mean, the argument has been that race is different than other things, so that one of the ways that they mitigated the impact of race is in the earlier decisions. And that's another reason, you know, to keep track of, we're talking about you lose things. There have been cases every 2 or 3 years upholding the ability to consider race. And this decision is, there's a legal concept called stare decisis, which means basically, we answered that damn question, leave us alone. And the idea is that you want to create some sense of continuity and stability, and so you know, Brown.
Not having the law change every 2 years.
Right, now, you know, Brown overturned Plessy, but it was 60 years later. And we in the area of affirmative action, in the area of reproductive rights, and I fear in other areas, maybe overturning decisions that were reaffirmed by the Supreme Court.
Voting rights is getting
Please.
decimated.
So one of the considerations, though, in the cases from Michigan, is they're saying, well, part of the consideration is, are you truly interested in diversity? And are you looking at all different kinds of diversity? So the recommendation that people would make is, if you're coming out with a policy, include people from the Midwest, include people who play the oboe, include, you know, all of these things, and don't include a pianist, because you don't want them.
We don't need any more of that.
And, you know, include as many people as you can so that race is only a little teeny tiny bit of it. But there was always this sense that race is somehow different and somehow toxic. And its toxicity comes in the fact that it adversely affects the opportunity for other groups, notably originally whites. And they were saying, you know, 14th Amendment, and you're discriminating against me because of my race, and you're letting in these unqualified Black people. And so therefore I'm not getting in. And that's a whole nother evening discussion about merit and things like that. But you know, the sense that race is different. And you know, there are so many reasons you could legally discriminate against someone. You know, you could, you know, discriminate against them because they wear a plaid shirt. And you know, yeah. And could you leave, please?
I do have to leave.
And you know, you would be stuck, you know, because it's not a protected category, but race has this special category. And it used to be special because there was this group that were dragged out of their country in Africa and forced to come here.
And not because of their shirts, but what's under the shirts.
So you know, that's really the reason.
Yeah.
One point of correction, my taking somebody's place.
No,
But there is someone who, are you on the verge of leaving?
Yes.
No, keep going.
God forbid a situation like this, anyone can be a usurper of someone else's place. But anyway, the first thing is a point of fact and correction. The last decade, the losses of the Civil War were probably closer to 720,000. 650,000 was the number that was adhered to for a long time. But that's just for the record. I'm interested that one of the things you didn't touch on was the way that the 14th Amendment and the Due Process Clause was used as a way to defend property throughout the latter part of the 19th century, up until, you know, that it was you cannot deprive a person without due process of life, liberty, and property.
Yeah, it is.
And it's really a defense used for the development of corporate capitalism.
It was both corporate capitalism, but also some other rights. And in the area of education,
yes.
You know, the Pierce case where the court said that parents had a property interest in controlling the educational choices of their children. And you know, there was a series of those, and I think, you know, a lot of those cases kind of disappeared in part because of a clarification that the First Amendment would be applied against the states too, and that became another means of challenging those. But yeah, and you know, the early 20th century cases, which you know that yes, yeah, Locke
also to what degree, and I should know, were these interpretations of the 14th Amendment modified, changed, reinterpreted in the progressive era? Is there a way? I've never heard that addressed quite directly.
I mean, I don't have a sense that the court was particularly progressive in that, because that was when Roosevelt was thinking about packing the court, in part because he was dissatisfied with it.
Thinking more like the era before,
like the Teddy Roosevelt era.
Yeah. I mean, I think then was when a lot of those corporate interests were being. We have time.
Okay, so
sorry about that. Pardon.
No, did you had a question or comment, right?
It's more of a comment.
Yes, please.
And for me, the 14th Amendment is one of my favorites as well. The other was one. But it was, as you were talking, I was thinking of So despite the 14th Amendment being passed, despite the 1954 decisions being passed, we've had another area in housing, we've had segregation in housing, they drew a segregation, government sanctioned. You had policies like, or government programs like the VA, specifically saying Black people cannot be given loans in these areas. So these are, and this has been in the 40s, 50s, 60s, ongoing. Although supposedly now these programs, these discriminatory practices have ended, we still see the badges, the vestiges of those policies to this day. So
Yes,
we have
and
these great tools, go on.
no, I'm sorry, please.
I was just gonna say, we have these great amendments, these great tools, but in reality, that we still see segregation playing out to this day when Black people try to get mortgages, for example. Those,
Yeah, and that's one of the reasons why the idea of colorblindness is so tragic, because in so many aspects of American life, it is still, and you talk about, you know, the labor laws, which exempted specifically home healthcare people and agricultural workers. And that was because they wanted to get the Southern support, and it would protect Black people from being protected by those labor laws. And those still exist, those exemptions still exist. And now it may be a different group of marginalized people who are hurting because of the lack of those protections. You know, I always, you know, tell people that everyone talks about what a great thing the GI Bill is. And, you know, it was great for some people, but it wasn't for everybody. And the impact of that still, you know, my father fought in World War II. And when it came time for him to get a house, he was limited about where he could get a house. And so in terms of being able to build up, you know, wealth by being in a neighborhood where the housing increased, you know, that impacts, you know, me and my children and things like that. So there are all of these ways, and they're just these constant reminders. The class I teach is in education, and it's just like everywhere, you know, gaps in terms of education, gaps in terms of wealth. You know, in New Jersey, the wealth of a white family is something like 20 times what it is of a Black family. And that plays out into the future. You know, all of those programs, you know, redlining was a government thing saying you cannot use this loan to buy in this area because there are Black people there. And all of that has and continues to have an impact. And so to say, you know, we're colorblind, to me is like saying, we're not going to pay any attention to the symptoms. You know, yes, you have 105-degree temperature, but we're going to ignore that and you'll get better.
We're applying strict scrutiny and affirmative action and saying, let's not look at race, but when it comes to housing.
Yes.
The very government is then
Right.
saying, well, property values, you know, they go lower because there are Black people in this area, so we're not going to give this mortgage. This was going on at the same time.
Yeah.
In 2020, I heard an acronym, ADOS, American Descendants of Slaves, in relation to affirmative action. And I just wondered if that was something, I heard it on CNN, if that was something that was written in to whenever they wrote this affirmative action law. Did it apply to only American descendants of slaves, or if immigrants came to the United States, they could benefit from affirmative?
They could. I mean, actually, that's one of the. It's a source. I'm on a reparations
Could you
committee.
briefly repeat what she said? Was a little soft, maybe.
Yeah. The question is whether or not affirmative action was limited to people who were the descendants of slaves, and so who therefore presumably suffered some of the impacts. No,
Talked about Obama, for example.
Right.
Yeah.
I'm on a reparations committee now in New Jersey, and that is actually a very fiery discussion, and it's a fiery discussion within the context of Black people. And so people are saying, listen, you know, you come from Nigeria and you were a rich Black person and you're in the United States. Why should you get reparations? we should limit it to someone. And to me, that feels divisive, really hard to administer, and ignores the fact that in one of our early sessions, we had Patero Sabuni speak.
Yeah.
And one of the most memorable, he is an extraordinary priest, and I don't know if he's a canon now or whatever, but he was from Uganda. And he said he didn't know he was Black until he came to America. And then told this just horrifying story about being arrested the day he was ordained for no reason, and and having his one call was to the Bishop of New York. But
and the white.
He was probably more Black.
Yes,
that's
yes.
right.
Well, yeah, so he was
And
a
I
criminal.
remember from that anecdote, the detail of the white policeman when Father Sabuni said, I have the right to make one call. I'm going to call the Bishop of New York, and the white policeman saying, "Oh shit!" Under that.
Yeah, he was
working on the wrong Black guy this time.
But the fact is, he had, and I wouldn't say that his life in Uganda was easy, because Idi Amin was trying to literally kill him, but he came to this country and he experienced discrimination, and the fact that he had been in another country did not shield him from that. And so I think, again, how do you quantify it? I mean, and am I only going to be able to get 50% of my reparations because half of my ancestors were white? And I mean, all of these other things are such complicated
very fraught.
issues.
Yeah.
Mhm.
We have 16 people currently joining us on Zoom. I don't want to let them feel left out. If one of you has a question or a comment that you'd like to ask, maybe you could raise your hand and unmute yourself. And because we are getting close to the end of our time, but if one or two of you have anything that you want to say, now would be great. Time to jump in. Not seeing or hearing anything.
There was a hand back there too.
Yes.
Was there?
Linda, did you? Oh, go ahead.
I think that somebody who hasn't spoken yet, Linda.
Yeah, Linda.
Thank you. I just want to mention Mamie Clark, who is Dr. Kenneth Clark's wife. And she was instrumental in this doll test that was part of the case. Oftentimes she's left out of the conversation, and she was right there with him all the way. He did not operate alone.
Yeah, you are right, and I'm sorry for not mentioning it. And she did literally do the research too. And while we're talking about things people who aren't mentioned, and this again, these meetings, you have to come to all of them because there's such good stuff. We had a discussion about Paulie Murray, who's one of the most extraordinary human beings who's ever lived. She was a lawyer and poet and a priest and all of these things. And one of the things is she had written a paper. She was the top student in her class at Howard Law School, wrote in 1949 or 1950 a paper about a strategy that could be used to end separate but equal, was derided by her professors, including Spotswood Robinson III, about this paper. And then the ideas were actually incorporated in the briefs in Brown 4 years later. And you could look all over and see no mention of the fact that that St. Pauli was a part of this.
Yeah, Blacks aren't the only group in our society that gets short shrift.
And just quickly, 14th Amendment has also been used for a right to counsel in Gideon v. Wainwright, in an end to miscegenation laws in Loving versus Virginia. They were part of the bases for Roe v. Wade. And then that's one of those cases where, in spite of being reaffirmed recently, the court abandoned it. in the Obergefell case, which is the marriage equality case, it's a 14th Amendment claim. I am scared out of my mind for each of those categories, the most recent ones that I talk about, because what happened in Roe versus Wade is the court said, the earlier decision, Roe, the court in Dobbs said, Roe was wrong. The 14th Amendment doesn't protect this. And what they did is they did a historical analysis, which is actually an interesting way of.
Well, that's what Dred Scott was, right? It was an
Right.
originalist argument.
And so they
What
went,
did the founders think? So.
and it says something about the way that law works, where because they couldn't show that, you know, that abortion was common at the time the 14th Amendment passed, then therefore it was not intended to cover that. At the same time, they do not subscribe to the idea that what was going on around the 14th Amendment as far as race
should be considered.
Yes.
Yeah. So they pick and choose. Dennis, one thing all of us here need to know about is the National Center for Law and Economic Justice. Take 2 minutes to tell us, please, about what you do there.
Yeah.
Why it's important.
And just very quickly, NCLEJ, the name is too long, but anyway, NCLEJ is a racial and economic justice organization that works in a number of areas. Low wage workers, we work on behalf of a lot of the people who were essential workers and who worked a lot of hours without getting paid for them. Restaurant workers, agricultural workers. We work on behalf of them. We work on behalf of people to make sure that they can get public benefits that will enable them to get back on their feet, which is the purpose of these programs. And they're prevented from doing it. We have a big case in Alaska now where you can't apply for public benefits. You know, you have to fly 150 miles to the nearest office, or, you know, you have to go online, but, you know, where you live, there's no internet and things like that. And so we try to make sure that people can get the benefits that keep you alive long enough to get back on your feet. We work on disability cases, and particularly cases where disability and public benefits interact. And we work on cases where there are structures that siphon money out of poor communities, what are called fines and fees cases, where, just quickly, a case in Buffalo where the city of Buffalo was literally balancing its budget by setting up stop points in Buffalo's Black neighborhoods, and then stopping every car that went through and writing exorbitant tickets for every possible violation, including one person who was charged per tinted window in his car. And that this is a way that's used to balance the budget, but it's a way that perpetuates economic inequality. I am pleased and thrilled that a number of folks who were here are supporters, and I appreciate it. If you're interested in our work, just go to nclej.org, and you could get our newsletters. And, you know, if you find some change in your sofa and want to send it our way, it would be appreciated.
Thank you for saying that, Dennis. So in 90 seconds, I'll be asking Father Hal Roark to do our closing prayer. Before I do that, I'll say a few other things. We will be having our next repair meeting in April. Don't have the exact date. We're working on topic and another compelling speaker. To keep in touch with what we're doing, of course, visit us on Facebook. And if you aren't already getting our monthly newsletter, please sign up for it. There's a sign-up sheet on the table here. Or you can write to us at info@repairrivertowns.org and just give us your email address, and we'll put you on our mailing list. You'll get the newsletter telling you about forthcoming meetings. I want to thank Ginny Lachlan and Ann Holmes for bringing snacks. Thanks, obviously, to the Warner Library for hosting us. This is really a nice, comfortable, kind of central place that many of us are able to come to. And of course, Dennis, for you taking the evening to give us It's been a number of months since we've been together. Isn't it nice to just be together? And, you know, God willing, there won't be another pandemic, so we'll be able to continue to do this. And Father Hal, if you would say a few words to God,
Sure.
send us home.
So I'm Hal at Grace Church, the merger of St. Paul's and Trinity. I'm new here. I've just finished my first year. I'm very excited to be here for many years to come. But as I get to know y'all, I don't know what you know or don't know. So I'm just going to start with something very simple, which is you're probably familiar, I think many of you, with the beautiful prayer Namaste that comes out of our siblings from the East in different traditions. Well, we have an Episcopal equivalent of that. And it is admittedly very British in its tone. It says the same thing, which is when we start a prayer, we'll often say, "The Lord be with you." And the response back is also with you. And it is the exact same meaning of Namaste, that the Spirit of me honors whatever path you're on, that God is with you and it's a return. So in this very brief, following my friend and colleague, Father Kevin's prayer from the prayer book, I will do likewise. The Lord be with you. Oh God, you made us all in your own image. Look with compassion on the whole human family. Take away the arrogance and hatred which infect our hearts. Break down the walls that separate us. Unite us in bonds of love and service and compassion, and work through our struggle and confusion to accomplish your just purposes on earth. Amen.
Thank you so much. Thank you all. Get home safely and hope to see you in a couple of months.